I want to welcome you back to the D-Lo Show. I am your host, Ryan D-Lo Delosier, and I'm back today to record a podcast. So yesterday, I was doing some work, listening to some podcasts, doing some things, around the house, getting some things taken care of, around the yard, all those things that you do, that we all do. And I came across there was the local news was on a podcast, and I had heard that the name Bryan Kohberger come up again. So, he's back in the news this time, and so here is the information. So if you don't remember who this gentleman is a loose term. Bryan Kohberger, he was convicted and sentenced last year to 4 consecutive life terms without parole for the 2022 murders of 4 University of Idaho students. He is now making major headlines once again. So nearly 13 months after pleading guilty to avoid the death penalty, Kohberger has broken his silence and filed a petition with the Ada County District Court seeking post-conviction relief to withdraw his guilty plea and secure a new trial. And then here are the key aspects of this that go along with this. So what he's claiming. So he's going to represent himself. Kohberger released statements to the New York Times declaring his actual innocence and claiming his original guilty plea was a result of bad legal advice, false promises, and misinformation. He stated, and this is a quote, "My actual innocence is my truth, and the plea must be withdrawn." This is going to be a legal gamble for Kohberger because by attempting to overturn his plea deal, he risks opening up the possibility of the state reinstating the death penalty if the case goes back to trial. And during this case, the state of Idaho, they reinstated. They don't have, they do have lethal injection, these humane ways of execution. But the state of Idaho also added the firing squad as a humane form of capital punishment. The families of the victims have sharply criticized this move, with relatives of the victims expressing frustration and calling him a narcissist. Well, he was a narcissist before, but he's trying to undo the agreement that previously spared his life. State officials have also indicated they are fully prepared to defend the conviction. So on Facebook yesterday, I saw that Steve Gonsalves had posted something. So first off, we're not surprised, even though Bill Thompson said with the plea deal all appeals would be waived, he knew that wasn't factual. Anyway, his time to appeal was running out, so September to be exact. And this is the Gonsalves family statement. So the mosquito you just can't seem to swat. That is what Kohberger and his following have become to this family. We read Mr. Baker's story, and he must be so proud of himself for speaking with Mr. Kohberger because the story didn't have much else in it other than a guilty man claiming he was innocent once again. Nothing in the story or in the Kohberger statement does he allude to the fact that he did not knowingly, voluntarily, and intelligently admit to murdering the 4 victims of this tragedy, Kaylee, Maddie, Xana, and Ethan. Quite to the contrary, he appeared in court in a hearing in front of a judge with his 4 lawyers. He did this after deciding not to leave his fate and the facts of the case up to a jury to decide his guilt. He never cried wolf or claimed he was uninformed, pressured, or that there were issues with the discovery that he and his counsel had for 2 years that he thought he should be challenged, or should have been challenged. He admitted to guilt and asked whether he actually was guilty. He said, "Yes, I am sure there will be a hearing as that is how the legal process works and the defendant will get another day in court. A nice break from his solitary confinement, getting to go for a ride, maybe some different food, photos taken, and the attention back on him and his innocence. The real issue is that if as much energy was put into honoring the victims in this case as trying to set a guilty man free, there would be statues of the victims on every corner with parks and days honoring their ultimate sacrifice, their lives, at the hands of a narcissist. Regardless of how this turns out, our family is 100% ready. An actual trial this time? Let's go. We are confident we will get the death penalty that he escaped by pleading guilty the first time around. Just an absolute waste of time and taxpayers' money. It's a disgrace. So, we are moving on. LOL. I guess I better get me a Death Row Records shirt for every day of the week now. So that was the statement from Steve Gonsalves, regarding the Gonsalves family. And that statement, definitely cuts right to the bone. Steve Gonsalves and the rest of the family have maintained that fierce, unyielding resolve from day one, and their frustration here is completely palpable. They are more than ready to go back into the courtroom and hold nothing back if it means finally getting a trial. The legal gymnastics of this whole thing are wild, even with the state prosecutors explicitly structuring that plea deal to strip away standard direct appeals. Post-conviction relief is a separate legal lane. Essentially, a collateral attack arguing ineffective assistance of counsel or issues outside the original trial record. Kohberger is basically trying to exploit a technical window right before his 1-year post-conviction deadline hits, trading his quiet life and maximum security for a headline-grabbing circus and a shot at a courtroom stage. So as the family pointed out, trying to blow up his plea deal is an enormous gamble. If he actually succeeds in withdrawing the guilty plea, he wipes out the very agreement that took the death penalty off the table. The state has already made it clear they are locked and loaded to defend the conviction. And if a judge somehow grants a new trial, prosecutors would likely reinstate the capital punishment immediately. And remember, as I mentioned earlier, Idaho has the firing squad. It is an exhausting, infuriating cycle for the families who thought this chapter was finally closed. But the legal process forces everyone back to square one. The state and the victims' families are clearly more than ready to meet him there. So if you were like me, or you may even know this, I thought that by pleading guilty, he was agreeing to waive all of his appeal rights. And I was wondering, is that true? Is that not true? How does this work? It seems like this is weird that he gets to appeal this now. And I was confused about this a little bit, so I went and took a look. And the legal system draws a very fine line and a frustrating line here. So when Kohberger took that plea deal, he did indeed waive his direct appeal rights. So in a standard criminal case, a direct appeal means asking the higher court to look at the trial record and say, the judge made a mistake during the trial, or the jury got it wrong, so overturn this conviction. But he pleaded guilty, and he gave up the right to ever make that kind of argument. However, what he's doing now is legally different. He's filing for a post-conviction relief. So here's the loophole that goes along with that. So a post-conviction relief petition isn't technically a direct appeal of the trial, since there was no trial. Instead, it's treated as a separate civil legal action where a defendant challenges the validity of the plea itself. So he is essentially arguing that his guilty plea was invalid from the start because he claims his lawyers gave him bad advice or made false promises, or that he was somehow misled into doing it. So under Idaho law, a defendant can ask a court to set aside a guilty plea and correct a manifest injustice if they can prove the plea wasn't made knowingly or voluntarily. So while prosecutors structured the deal to block standard appeals, the law almost always leaves this narrow backdoor avenue open for defendants to challenge whether the plea agreement itself was legally binding in the first place. It's a technicality that allows him to try to blow up his own deal, risking death penalty all over again just to get back into the courtroom. So the New York Times is saying that this is an interview they had with him, and so Kohberger was breaking his silence for the first time since his sentencing, which happened 13 months ago. Kohberger provided statements in an interview to the New York Times from a maximum security prison to announce his push for post-conviction relief. And so in the communications with the paper, he claimed that his original guilty plea was driven by coercion, false promises, and bad legal advice, stating, "My actual innocence is my truth, and the plea hinged on false promises and blatant disinformation must be withdrawn." So in the report published by the New York Times, the paper detailed Kohberger's outreach from maximum security and published direct quotes from his communications. So the key elements featured in the Times include the following right here. So his direct statements. Kohberger provided a written statement declaring, and this is quotes, "My actual innocence is my truth, and the plea hinged on by false promises and blatant disinformation must be withdrawn." And must is capitalized, like he's yelling it, must be withdrawn. Pound the fist on the table. He also stated, "I hereby declare my intention to enter a not guilty plea and welcome the state the opportunity to prove their case at trial as well as go to, again, file for the death penalty." So yeah, he's acknowledging that that is a possibility, that if this goes back into court, that the death penalty could come back up again. In a phone call with the Times from prison, when asked why he was speaking out now, he said, "A lot went wrong in those plea discussions. I really do want to be heard." You know, he really didn't want to speak up when he had the opportunity, though. And even on the last day when the families came in to say on the sentence and everything as well, too, he just sat there and, respectfully declined to comment. So, yeah, I mean, he had his opportunity, but now he wants that opportunity again 13 months later because he's had 13 months of solitary confinement to think about it. Yeah, I don't think this is going to work out too well for him. And he has claims against his legal team. Now, if you followed this like I did, these are all bunk. The reporting outlines his core accusations that his former defense attorneys, which were led by Ann Taylor, and the plea process involved coercion, false promises, and bad advice, framing the original state's case as a work of fiction. Yeah, that's interesting as well, too. And then there were some messages of gratitude. So at the end, in his statements to the paper, he also offered thanks to his supporters and sent love to his family for never wavering in their belief of his innocence. Yeah, I don't know if they've wavered or not. You remember going back to that? Let's turn this music down here a little bit. I do remember that one of his sisters was actually wondering, he had the white Elantra. He's acting weird. He's wearing gloves around the house. Yeah, there was all this weird stuff that he was doing. Yeah, that guy, that family who never wavered in his innocence, right? When they were believing he was guilty before he was even a guy who was on their list of people who they were searching for. So before the police department even knew, his family knew. So other than statements from the Gonsalves family and Kohberger himself, the broader circle of key figures, including his former lead defense attorney, Ann Taylor, in the Latah County Prosecutor's Office, the prosecutors actually have said something. I'll get to that a little bit later. And then the judge handled the case. They have not publicly weighed in on or issued formal statements regarding this sudden post-conviction relief filing and interview regarding the interview at the New York Times. So the next steps in this case. So now that the petition has been officially filed by the Ada County Court, the legal process moves out of the press and into a formal judicial track, because post-conviction relief is treated under Idaho law as a separate civil proceeding rather than a standard criminal appeal. A specific roadmap must unfold before any courtroom showdown happens. So how this is going to work. So there's going to be an initial review by the court. So a judge will review the petition. to determine whether Kohberger has raised legally viable claims. If the claims are completely baseless, which kind of appears to be this way, or fail to meet the strict legal thresholds for overturning a guilty plea, the judge can issue a notice of intent to dismiss the petition outright. Then what will happen from there? So there's an appointment of counsel or pro se status. Because Kohberger is currently listed on the docket as represented himself, which is pro se, he will have to manage the legal filings, motions, and arguments on his own. And, as a PhD candidate, this probably is within his wheelhouse, you'd think, and he would also know, but you'd also think that he had 4 attorneys working for him, and you'd also think that he'd be able to know right from wrong and be able to, kind of analyze the whole process of him being a PhD candidate kind of backfires when he's saying how his counsel was not good and they gave him bad information and misled him. But he's the smartest guy in the room. Just ask him. So the post-conviction process that goes along with this, I'm not sure a public defender would really want to defend him anymore too after he just threw Ann Taylor under the bus. All right. So the state's response to this, what they'll do next is, if the petition survives the initial review, the state of Idaho, through the prosecution, will be formally served and required to file an answer or motion to dismiss Kohberger's claims, defending the integrity of the original plea agreement and the adequacy of his former counsel. Then there will be evidentiary hearings. Again, if the judge finds that there are disputed issues of material fact, especially regarding his claims of coercion, bad advice, or ineffective assistance of counsel, the court will schedule an evidentiary hearing. This is where witnesses could theoretically be called, and Kohberger would have to present actual evidence to support his claims under oath. And then there will be a ruling. So after reviewing briefs and arguments, the judge will issue a formal ruling. If the judge denies the petition, the conviction and life sentences stand. If the judge grants it, a guilty plea is vacated, the case is effectively rewound, and prosecutors would have to decide whether to take the case to trial and reinstate the death penalty. So again, I kind of followed this really since the onset, before Kohberger was even a suspect, and I was wondering, are there any legally viable claims? Is the state required to provide him with legal counsel? So whether Kohberger's claims are legally viable, it's an uphill battle for him. And legally speaking, the state is not automatically required to provide him with a free lawyer right out of the gate for this type of civil filing. So the viability of his claims, legally overturning a conviction after a guilty plea, is exceptionally difficult because of the extensive record created when the plea was originally entered. And if you followed this, this was recorded, you could watch it on video. So when District Judge Stephen Hippler accepted Kohberger's plea, Kohberger explicitly stated under oath that he was not being coerced, that no outside promises were made, and that he was fully satisfied with his legal representation, which was led by Ann Taylor, and that he was pleading guilty because he was actually guilty. I can almost see it in my mind right now. You go look it up. Judge Hippler telling him, and you are pleading guilty because you are indeed guilty? He says that to him. To succeed on a claim of ineffective assistance of counsel or an involuntary plea, a defendant has to prove that their attorney's representation fell below an objective standard of constitutional level failure, and that it directly impacted their decision to plead. Overcoming his own recorded statements in open court, where he swore he was satisfied with his lawyers, represents a massive evidentiary hurdle. And then, as I mentioned before, he's a pro se status, so Kohberger filed an initial petition representing himself. And under Idaho's post-conviction procedures, a petitioner does not have an absolute constitutional right to a publicly funded attorney for a civil post-conviction challenge immediately upon filing. However, if the court reviews the petition and determines that it raises legitimate, complex issues and survives initial dismissal, or if an evidentiary hearing is actually ordered, the court can choose to appoint counsel to represent an indignant petitioner. If the court finds the claims frivolous or legally meritless, he will remain on his own to manage the case from maximum security. One thing I was wondering is, like, how common is this? And, really, I think a lot of criminals, a lot of people that are in jail, they start thinking, they got lots of time to think, and they get a little what's called buyer's remorse. So it's a relatively common for high-profile defendants to experience buyer's remorse after pleading guilty to avoid the death penalty or life imprisonment. But successfully pulling it off after a full year has passed and after the judge has formally accepted the plea is exceedingly rare. Legally speaking, there are two distinct patterns that emerge when defenders try to unwind a guilty plea post-sentencing. So there's the buyer's remorse pivot. It happens frequently in capital or high-stakes cases where a defendant takes a plea at the 11th hour to save their life, only to later realize the reality of spending decades or life in maximum security confinement. They try to claim coercion or bad legal advice. However, courts almost always reject these unless the defendant can prove a gross constitutional failure by their attorneys. And then what makes this case stand out is the sheer level of risk involved. Most defendants who try to withdraw a plea are serving lesser sentences and have less to lose. When a defendant who traded away a death sentence tries to blow up the deal, they are essentially daring the state to bring back capital punishment, turning what was a closed chapter back into an active legal war zone, which happens to be a legal war zone that is backed at the end by a firing squad. So through my eyes, when I saw this, I thought Judge Hippler covered his bases when they went through the plea deal last July. I remember listening to the pleas, and they were repetitive, they were thorough, and Judge Hippler absolutely built an airtight record during that change of plea hearing. They were going to go to trial, and then all of a sudden they came in with a plea deal. Between a detailed 9-page written plea advisory questionnaire so when he did this, there was a 9-page written plea advisory questionnaire that Kohberger filled out. He initialed, he signed it, and then followed by an extensive series of direct, repetitive questions from the bench. The court went out of its way to leave zero wiggle room. So Judge Hippler explicitly asked him if he was being coerced, if there were any outside promises, if he was satisfied with Ann Taylor and his defense team. These are all things that now he's saying that he was given some promises, that his defense team was not good enough, and then specifically, he was pleading guilty because he was actually guilty. And he answered to all of these, yes. And now he's trying to say he's innocent? That thoroughness that Hippler did is precisely why legal experts view his current post-conviction petition as such an uphill climb. Overturning a guilty plea after swearing under oath to all those things requires overcoming a mountain of his own recorded words. And I felt like Ann Taylor was amazing in this whole process right here. She drove me nuts because of all the things, because she's defended a monster. But really, she did an excellent job. She tried to get everything thrown out. Okay, Hippler even made a few comments on her as well as he was going through, and she'd been over backwards. And now he's throwing her under the bus. So Ann Taylor and her defense team certainly threw everything they had at the wall during the pretrial phase. They were fighting tooth and nail on complex issues ranging from the state's use of IgG, the investigative genetic genealogy, to attempts to introduce theories involving alternate perpetrators and challenges over massive terabytes of digital discovery. Judge Hippler pushed back on several of those expansive strategies, such as dismissing the defense's alternative perpetrator theories as requiring rank speculation by a jury, and noting during hearings regarding massive digital data dumps that much of the surveillance footage being waded through was likely irrelevant noise rather than hidden evidence. And she complained during that time too, but just not having enough time to go through everything, and that the prosecutors weren't labeling stuff for her for where she's supposed to look. She had from 2022, from when basically it's 2023. So we'll just go with January of there, all the way until July of 2025. So that is a long time right there to be able to go through and look through all of this information, this mountain of information that they had, a Mount Everest of it. And just looking, didn't have time to do her work right there to be able to look through. Well, it's hard to find, but it was right there in plain sight as well too. So I was trying to look for, like when they were trying to find, an alibi or the evidence that would exonerate him. It didn't exist. That's why it was not in the terabytes of information, because that exoneration evidence did not exist. Watching a defense attorney battle relentlessly through all those motions only for the defendant to later turn around and claim bad legal advice is a stark twist, to say the least. So as I was researching for this information right here, I also saw that Latah County Sheriff's Office, they made a statement on their Facebook page, and it's from the Latah County Prosecutor's Office. That statement from Latah County, here's what it was. Let me read this to you. It says, "We are saddened by the recent news that the admitted murderer of Maddie Mogan, Kaylee Gonsalves, Ethan Chapin, and Xana Kernodle continues his efforts to victimize their families and friends. Our office is prepared to defend the well-deserved convictions and sentences and ensure justice prevails. No further statements will be made at this time." I really appreciate what they said, how they said it. And like they said, the victims' names: Maddie, Kaylee, Ethan, and Xana. The four there that should have their names mentioned, and then referred to Mr. BK as the admitted murderer. The admitted murderer. He did do that. He admitted it in court, and then he was asked, "And you are pleading guilty because you are guilty?" And he said yes. That statement from the Latah County Prosecutor's Office is short, measured, and completely hits the nail on the head. They aren't taking the bait to get into a public media back and forth with him, but they are making it crystal clear that they view this whole maneuver for what it is: another calculated attempt to keep dragging the families through the mud. By noting that he is continuing his efforts to victimize their families and friends, the prosecutor's office underscores the exhausting emotional toll of these kinds of legal stunts. Prosecutor Bill Thompson and the state team put years of airtight work into building that case, and their message signals that they are entirely unfazed by his handwritten petition. They are locked in, fully prepared to defend those convictions, and ready to shut down any attempt he makes to rewrite what happened in that courtroom. So this all went down on Monday and pretty much covers kind of the landscape of this sudden development that happened. I wasn't really expecting to hear any new information. Kind of stuff just keeps coming up, and it's usually, people coming out with, as evidence comes out from the case and things get released and people do FOIA requests. But this is a new one. It gets his name back in the forefront. Between his handwritten filing with Ada County District Court, the stark pushback from the Gonsalves family and Latah County's prosecutor's office, the steep legal mountain he's facing to override his own sworn statements from last July, the stage is set for the heavily scrutinized procedural battle. So, just kind of things that are going through this right here. The case is, we'll just kind of see how it goes. The wheels of justice move slowly in this. And we'll just kind of see where it goes from here. So I want to thank you for listening to this episode. If you like it, go ahead and subscribe, follow, share with your friends, and let others know about the D-Lo Show. I'll keep posting stuff. If there's anything else you want to hear, I know this isn't necessarily, it is local. It's in the Northwest area. I've covered it a few times on my podcast, but if there's other stuff you want me to cover, go ahead and let me know, and I will. I'll be posting more stuff as we get going. So I hope you're having a great day.